I think I was invited to comment as one of the frequent targets of Jed's ire in his many pieces, trying to dismantle this formalist theory of the removal power. But I was rather surprised and pleased to find that Jed was quite nice to me in the paper. And it was Mike McConnell who got the brunt of the criticisms, so I will likewise try to be pleasant. And Michael is free to get on the queue. Having said all that, I don't buy Jed's argument. Jed seems to think that the existence of inalité, the buying and selling of offices, and more generally property interests in offices in England in the 18th century and before, disproves the majority view among originalists that the president has a removal power. So what I'd like to do is to sketch out what I think the argument for the removal power is, and why I think Jed's argument, Jed's piece, actually supplies lots of good evidence for it. Now, I should add that Jed's work overall, he mentioned a number of his pieces, has been very important and has made me rethink many of the details of the steps in the argument. So Jed may be wrong, but he cannot be ignored. Step one. Let's start with Jed's concession that the power to appoint includes the power to remove, which he elaborates in much more detail in his Indecision of 1789 paper, which is still, I think, forthcoming in the Penn Law Review. I call this a concession because it shows that despite Jed's numerous statements to the contrary, the king, by default, had a removal power. Even Jed recognizes that the king had the power to create and appoint to offices, unless Parliament provided otherwise. Blackstone says the king, being the fountain of honor, has the power to erect offices and to dispose of them, that is, to distribute those offices or to appoint to them. Well, if he can appoint to them, he can remove from them too, because the power to appoint includes the power to remove. Again, a point Jed accepts. That explains why Blackstone does not have to mention removal specifically as a royal prerogative. This also allows us to make sense of Giles Jacobs' book from 1779, Every Man His Own Lawyer, which Jed quotes on pages 33 to 34 of his paper. Jacobs basically borrows Blackstone's language on being the fountain of honor and erecting and disposing of offices, but he paraphrases it as follows. The king creates, makes, and removes the great officers of the government. So here's a gloss on Blackstone and this interpreter, who according to Jed was widely read in America, thought that disposing of an office meant you could also remove from that office and put someone in that person's place. Okay, that's England. What about America? Step two. It turns out that the default rule is almost certainly the same here. The president is granted the executive power. The executive power is the power to execute law. And even Julian Mortensen admits in his paper, I say admits, concedes, argues, in his paper on executive power, that the power of appointment was a part of the power to execute law. Here's Julian. I think this is the Penn paper, not the Columbia paper. George Mason was in good company in considering the appointment of public officers closely linked to the executive power, sometimes as a strict conceptual element of the thing itself, other times more loosely as an indispensable buttress for its meaningful exercise. So, if the executive power is the power to execute, if the power to execute includes the power to appoint assistants, if the power to appoint those assistants includes the power to remove them, then the president has the power to remove, unless that power has been modified by the Constitution. Now, as Jed says, perhaps the Senate shares in the removal power because the Appointments Clause modifies the president's powers in this respect. This was the position of what he calls the senatorial faction in 1789 in his other work. But as Chief Justice Taft said in Myers, at least plausibly, it's the president who nominates and appoints. The Senate merely advises and consents to the appointment. Now, it's not true just because Taft said it, but I tend to agree with Taft because it's just argued or described, both appointments and removals are really incident to the grant of executive power. And so the removal power flows from that grant, not from the Appointments Clause. Another reason to think this is the case, by the way, is even if the president's power comes only from the Take Care Clause, a legislative veto, a senatorial veto on the president's removal could prevent the president from exercising the take care duty, transferring the duty to the Senate, which just can't be right. Okay, step three. The question now is whether something else in the Constitution modifies this default rule or allows Congress to modify this rule. In England, Parliament was supreme and could always change the institutional arrangements. As Jed says, over time, Parliament made many offices more responsible to the king or to Parliament and less hereditary, but at times it also made them less responsible to the king, as they did in the Act of Settlement, which changed the default rule that the king could remove judges who assist in the execution of the laws. Parliament's supreme power allowed it to create property interests in offices or not. The question then is, what does our Constitution do with all this? Whether Congress, like Parliament, can derogate from this default rule or alter this default rule depends entirely on its power. And the question is, did our Constitution, which creates a republic and specifically assigns governmental power, give Congress any power to create property interests in offices? Step 3A. We know no clause explicitly gives Congress this power, so it has to be the necessary and proper clause. We know Congress can establish offices, it can set tenure, namely the length of offices, it can establish duties, it can even establish qualifications, and perhaps it can establish conditions on which a convicted officer is to be removed by a court. All of those things plausibly carry into execution Congress's own powers or the president's powers, but none of that answers the question of whether Congress can create a property interest in the office, like venalite, and thereby prevent the president from removing that officer without some kind of cause, say. Aside from the obvious limit that Congress can't create hereditary offices, which I think would be titles of nobility, I'm not sure, but I'm pretty sure, the text of the necessary and proper clause arguably answers the broader question, just like Congress can't pass a law pursuant to the necessary and proper clause that says the president's overworked, there shall be 2 commander-in-chiefs. I don't think Congress can pass a law that limits the president's power to remove principal officers because that would hinder the president's power of law execution. Okay, but even if that's not persuasive, which maybe it's not, the question of what powers are necessary and proper would in some sense be one of background principles. Step 3B. Jedd's most on-point historical evidence in this regard is from the colonial experience, where Americans universally complained about and rejected the practice of buying and selling offices. Jedd concludes that despite this, there is no record of Americans abolishing the sale of office or ending office as property legal regime. That's page 32 of his paper. Fair enough, but there's no record of their adopting this practice either. That's a question of constitutional meaning, of assigned and distributed powers. And since we're under the necessary and proper clause, if anything, this history strongly suggests that they would have thought such practices derogating from the executive power, and perhaps more broadly from Republican government. I think the irony here is that Jedd accuses unitary executive theorists of using royalism as a guidepost for a Republican chief executive. Of course, the framers understood the royal system to be some guide for executive power, but only as far as Republican principles will admit, right? That's Hamilton. It's Jedd, I would say, that is using a system that Montesquieu described as being part and parcel of a monarchy as evidence of how the framers would have understood office holding in a republic. So the question, I think, is, in a republic, do officers who exercise government power trace their authority to elections and appointments and ultimately thereby to the people themselves, or can you have property interests in such offices? I think the question answers itself. Step 4, short step. It's important to be clear that none of this requires the ability to remove inferior officers. They can be protected from removal so long as they have to follow instructions from their principal. The Secretary of War may have to court-martial a cadet to remove him, but the cadet still has to follow orders. And if we want to insulate the decision-making of lower-level officials from presidential interference, think adjudications, that's fine too, as long as the president or principal does have the power to freely remove. So tenure and property-like protections in office may very well be permissible for inferior officers because those protections don't have to derogate from the president's power of law execution. Conclusion. Here again is the story in capsule form. The president has the executive power. That includes the power to appoint, which includes the power to remove. The power to appoint requires advice and consent, but the Constitution says nothing about requiring advice and consent to remove. Congress has power under the necessary and proper clause to create offices and establish tenure like terms of years. What it can't do under this power is restrict the president's ability to remove principal officers because that would be derogating from the president's power of law execution rather than carrying that grant into execution. What Congress can do is restrict the ability of the president or principal officers from removing inferior officers. But there's nothing wrong with that as long as they're truly inferior and have to obey the orders of the principals. If they refuse, maybe they can't be fired easily, but their acts would be ultra-virus. So here's my question. What's wrong with this story? What in any of Jedd's many articles on the subject disproves it? What in any of Jedd's articles is inconsistent with it? And I want to be clear about what I'm asking. There could be other stories to tell. There could be other possibilities of meaning. My question is only whether anything Jedd has written disproves this story, a story which I think does make sense of the text and the history and makes sense of the fact that we're a republican and not a monarchical government.
The thing that I'm struck by is throughout your commentary, and particularly where you ended, was the emphasis on a republicanism as opposed to royalism, which is, I think, my core argument. And in fact, when you say, there's no ire here. But what I will say is that, in fact, there's respect. And one of the most important one of the most important approaches that you and Michael McConnell have embraced is the concept that prerogativism, as opposed to royalism, is an appropriate way to make sense of the history and make sense of executive power, emergency power, though limited by law. And so one of the things that I just want to emphasize is that both you and Michael have an important point of method, and I'm embracing it, and I'm also holding both of you to it. But before I get to that method of prerogativism, I think it's also an open question, and maybe not even such an open question, of whether that's the right approach at all. And the person I'm the harshest about, maybe, is leading with the point, or maybe I'm just holding Eric Nelson to what he has on page 1, which is, he says, he quotes June 1st of 1787 for the point for opening up on page 1 of the Royalist Revolution, emphasizing a prerogativism in the convention. And it turns out that when you open up June 1st in Farron's records, it says the opposite of what Eric Nelson says it says, which is that both Madison and James Wilson, but most explicitly James Wilson, says, I'm not looking to the prerogatives of the monarchy as the model here. So let me just say, first of all, I think it is highly contestable of whether royalism or prerogativism is even appropriate where you ended, Elon, which is about this is a republic, not a monarchy. That's true. But even if we adopt McConnell and Werman's prerogativism, it clearly does. There is no evidence of the removal power as a prerogative. So let me just take from McConnell's book. And I agree with this framing, and I think it's important. And most of the book, I frankly think, stands up and is very important on purpose, scope, and methods. But Michael says, prerogative is therefore associated with the Schmittian conception of sweeping emergency powers and an unchecked executive. In the British constitutional tradition, however, the prerogative powers were defined by law. The king could act unilaterally within his prerogatives, but not range outside them. In this tamer version, the law defines the bounds and subject matter of prerogative powers, but does not govern the content of decisions made within those bounds. Under the common law, executive decisions based on prerogative could be challenged as ultra vires, but not as unreasonable, unjustified, or ill-motivated. And so both Elon and Michael rely on the listing of prerogatives as the legality of extra legality, because otherwise we go in a Schmittian direction. And so that I embrace that method. I think that's important, even if it's dubious from the convention, but I'm also going to hold both of you to it. And if you can't show me, and frankly, no one has identified where removal is a prerogative, then it doesn't fit that method. So that's that's one of the most important points. But just to say one more thing about Elon, you emphasized and said repeatedly, the power to appoint also means the power to remove. And I just have 2 words to respond to that, which is Article 3. Right? The power to appoint depended upon the definition of those offices. And so the nature of offices that were both executive and judicial did not mean that the power of appoint created a power to remove. And in fact, it wasn't limited to Article 3. If you go back and read Marbury versus Madison, Marshall says several times that William Marbury was unremovable. Well, he wasn't unremovable because a justice of the peace was an Article 3 judge, because he had a term of office for 5 years. And I'm building on the work of Jane Manners and Lev Menand here. They explain Marbury, and it is that, and Jefferson clearly understood this as well, because otherwise, why did they moot the case by removing him? This was the extension of this power. So, one final point about the sources here. I mean, this idea the concerns about the Senate. Well, just quickly, in terms of the sources from the founding that the unitary executive theorists have to overcome. The convention lines up against the unitary theory or the idea of these powers being implied by executive power. That's Madison, that's Wilson, and that is the rejection of the Gouverneur Morris Pinckney Plan of August 20th. Federalist number 39, Madison embracing this idea, the tripartite categories, including offices for a term of years and life tenure. Hamilton, Federalist number 77, recognizing and saying the senatorial position was the right position. Then the ratification debates and their silence. And in fact, you started with Luther Martin. Luther Martin is some of the best evidence here in terms of saying that the only time in the 6 volumes in Storing's papers where an anti-federalist warns of a removal power, the only time among all of those debates that were identified by Herbert Storing about the executive power, Luther Martin says the problem for the presidential power is the power to remove military officers. What is the basis for Luther Martin's concern about removal? It was the explicit enumerated commander-in-chief power. If they were going to point to a source for removal, it's striking that Luther Martin narrowed it to the military based on an explicit term. That tells us something, that removal was not implied even among the ratifiers most incentivized to raise or exaggerate the problem. Not even they would raise that argument.